We're now having a look at the section B, which is the module 2 component of the 2017 Law Unit 1 paper. And we start off with with outlining the three universal principles of the rule of law. What are the three main principles of the rule of law? This is where we answer now. What are the three main principles of the rule of law? Waiting for somebody to go ahead. No, so it can't take so long for somebody to just unmute and just shoot all three of them quickly. What are the principles? Go ahead.
Sir, is it equality before the law, constitutional rights, and absence of arbitrary power?
Okay, those are Dicey's principles. Those are all Dicey's principles. Okay. So three
But can they
universal
be
principles.
used? Oh,
Okay, the constitutional power one though, right? I wouldn't say that's a universal principle, right? When we talk about the universal principles, we're speaking about things that affect, well, you know, universal means, right? It can be used in any situation, right? So here I would probably prelude to, well, I probably would go to the Declaration of Delhi, but go ahead.
Sir, what about the protection of individual rights, equality before the law, and absence of arbitrary power?
Okay, wait, hold on. We're looking at the principles of rule of law, you know, not what it does or not what are the effects or not what it upholds, but the principles, the core principles of the rule of law.
Sir, is one of them no man is above the law?
Yes, that's a principle. Because everybody else is saying something that the rule of law assists with, right? No man is above the law. Explain that. That's a principle. What's the next principle? You are innocent until proven guilty. Lovely. What's the next principle? Go ahead, I think did I say Randy? Did you know? Probably was from before. Anybody next principle? So no man is above the law. Everyone is innocent until proven guilty. So they fear that's really the encompassing the fair trial and the right to be heard. Right? What's the last one? The last one? Okay, I'm not sure what the issue is.
Sir, is it that law should be equal to all?
No man is above the law, okay. That's generally it there. So there's equality before the law, which is no man is above the law. That is generally what we used to talk about here, right? Accountability due to through due process, right? No man is well, everyone is innocent before proven guilty, and we also have transparency and clarity of the laws, the predictability of the legal system, and the transparency of the legal system. Those are the three universal principles of the rule of law: transparency, equality, and accountability. Three main principles. All right. B. Elections are held in the state of Greluk and the People's Party comes into power. The first act of the new government is to confiscate all lands belonging to the former sugar plantation owners, including Mr. Williams. No compensation is paid to any other plantation owners. Mr. Williams is detained when he prevents government officials from entering his property. Advise Mr. Williams on whether or not he can successfully bring an action against the state of Greluk for breach of his fundamental rights. Use two decided cases to support your argument. Please go ahead. Identify the issues, advise the man. I have a question. Maybe you guys may answer in the chat yes or no or whatever, right? Is module 2 the most complex of the modules?
No, sir.
Okay, alright, lovely. So we can answer the question in quick succession then. Right? You need some time to think though, to look at the question and see if you can pick out ways in which you could assist him.
The issue was that he took the land belonging to the farmers of the sugar plantation and did not compensate the plantation owners.
They confiscated all land, right? And there was no
Yeah.
compensation, alright? And they detained him when they prevents the government official. Well, detained him when government officials. Okay. Alright. So it's these issues now.
So
Go ahead.
they breached is freedom. They breached the protection of his property
Mm-hmm.
and so I don't know if I'm answering.
I don't want you guys to not be confident, but go ahead with the confidence. Tell us what you're
So
thinking and let's think about it.
this is what I'm thinking,
Okay.
right? They breached in the constitution it says that no one should be deprived of their personal property,
Mm-hmm.
right? And in Guyana, that is, I think, Article 19. So, because the government officials breached the constitution, which is the supreme law of the land, and according to the rule of law, the whole idea of the rule of law is that the law is applied equally and fairly. So for them to confiscate or just as I take all the land belonging to the farmer sugar plantation owners and give no compensation, they are not being treated fairly there. No equality is there. So
Mm-hmm.
it breached their protection. It breached the protection of their right.
Mm-hmm.
And yeah, that's what I'm thinking.
Okay. So, not sure if anybody wants to go before I go. Alright? Because you guys can raise your hands to let me know that you want to say something about it. But in the first place, confiscating of all lands belonging to the sugar plantation owners. Not sure what the issue was, but that's a breach of the constitution. That is unconstitutional, completely out of the way there. You know it's unconstitutional. Nope. Breach of a fundamental right which is enshrined within the constitution. That's my first point there that I see in the question. No compensation paid, breach of natural justice. Right? Complete breach of natural justice. Right? And then he was detained when he prevents government officials from entering his property. Or would that be a breach of right to privacy? Not necessarily. Right? But he was trying to defend his property. And then he was detained. Right? So we're looking at that. That would be wrongful detainment as well, because if everything that you're doing is wrongful, then you detaining him would still be wrongful. Alright? So we're looking at the fact that these are issues, right? With the constitution, contradictions with the constitution, allowing for the laws that allow this new government, right? This new act, right? The first act of the new government is to do that, right? This is unconstitutional. Speak to your constitutions about this. Cite your constitutions and speak about what are the issues with what is happening here. Speak to the no compensation part as well with natural justice. This is a 15-mark question. For the two decided cases, what two cases would you use to support your arguments here? Because the thing is now, you're supposed to advise whether or not he can successfully bring an action. And I think he most definitely can bring a successful action. Right? Via judicial review. So you're going to also mention that, right? Judicial review. The power of the courts themselves, the Supreme Courts generally, to actually review all these decisions made by the government, right? That will infringe upon the rights of these people. Speak about that. What are the two decided cases?
Sir, one of them could have been King versus AG Barbados.
King, alright.
Yeah.
Mm-hmm. King, that would be a lovely case. What's another one?
In terms of its right to its personal liberty, I would say Maharaj versus Attorney General of Trinidad and Tobago because that's
Maharaj.
easy.
Yes, yes. So Maharaj versus Attorney General of Trinidad and Tobago and King versus the Attorney General. Lovely. Two lovely cases. And all you need to do now is look at the information, bring out your concepts of the rule of law, natural justice, breaching the constitution, especially with the rights, right? The rights, fundamental rights and freedoms that are entrenched into the constitution. Speak about the court's right to or not really the courts, no, the court's duty to judicial review and your right to us to actually look for judicial review, and speak about how successful this may be, right? I think it will be successful, and I will speak about this breach of the fundamental rights, and I'll speak about the process of judicial review and these cases that can be used to support my point. These are the things that you must bring up. Here now we're asked to outline essential features of the right to be heard. I completely discussed that. What are the essential features of the right to be heard? Three essential features of the right to be heard.
There's the right to be given reason behind the decision. It's the right to be given notification of the evidence that is against you and the right to answer against that evidence.
Okay. So we have those three. Hopefully everybody heard that, right? The right to notice, right? The notice of the hearing, right? The opportunity to be presented with evidence and arguments, right? To present evidence and arguments, right? The impartial decision maker, right? The hearing must be conducted in a neutral bias or neutral ground, right? And then there are other features such as you must be notified of the charges, you must be aware of these issues. So the right to be heard must be there, right? So you need the notice of the hearing. You need to basically be noticed why you need to know your charges, what are charges for, why are you going to be charged, right, and stuff like that. We need to have an opportunity to present evidence, so you need a right to be heard. The individual needs to have the right to say something, to provide evidence, right, to present evidence to defend his or herself, and we must have impartial decision making occurring. The hearing must be conducted with neutral and unbiased decision making. So these are the three essential principles of the right to be heard. B, in the state of Bonaba, right, the government provides free education up to tertiary level. Lovely, right? Could never be a real Caribbean country. Could be Barbados. In 2016, the government decides that all students entering university in 2017 will have to pay 20% of the university fees. Interesting. Alright. Nolan, a student from a poor family, cannot afford to enroll in his third year of university. Advise Nolan on whether or not he can successfully bring an action against the state of Bonaba, right, for breach of his legitimate expectation. Right? Use two decided cases to support your argument. Go ahead.
Sir,
Go ahead.
when they stated that we should advise, should we write an IRA question?
Advise. No. IRAC is generally used for cases, no. So your supporting cases can be in IRAC format, right? And then your conclusion, right, could your conclusion itself would have been the advice per se, right? So it's not that everything should be in IRAC format because IRAC is done with cases, right? You can do it, you can actually do it in IRAC format though. I think IRAC format would have been nice. You can. I'm not that I'm thinking of it. You can, because you have an issue, right? You can provide the cases in the rules, right, you can have an analysis and a conclusion. So IRAC would be lovely, actually. Now that I think of it, I did all my questions in IRAC format. So I think IRAC format would be nice here as well. You could do that. Right? It's a possibility. Of course, with A you can the IRAC format, but with B you can the IRAC format. You can speak about the issue, and you could speak about the rulings, right? Come decided cases. You could use the two deciding cases speaking about in your ruling and analysis, and then in your conclusion, that could be whether or not it would be successful. So IRAC could work. All right. So we have the general issue here, right? Firstly, we're speaking about the legitimate expectation. What is legitimate expectation? What does that speak to? Anyone? So let me highlight the issue. The issue is the entire first paragraph. The entire first paragraph is the issue. Right? And you speak about Nolan's situation as well as a part of the issue. This is the entire issue. Right? What is legitimate expectation again? Everyone is entitled to the right to their... Go ahead.
Sir, it is concerns the relationship between the public administration and the individual. It seeks to resolve conflicts between the desire to protect the individual's confidence in expectations raised by administrative conduct and the need for administrators to pursue change in policy objectives.
All right, that's a complex definition, right? But essentially, what it really speaks about is a doctrine, right? It's still a legal doctrine, right? So it's a part of administrative law that protects individuals against arbitrary changes in government policies or practices. So it prevents them from arbitrary changes. So here, what did the state say, right? The state provides free education up to the tertiary level in 2016, right? Then, in 2017, right, the government decides that all students entering university in 2017 will have to pay 20% of their government fees. How that of their university fees, right? What we're gonna look at now is how that breached legitimate expectation. You just stated in 2016 that you're gonna cover the fees up to tertiary education, and then in 1 year, you're not even sure if it's a full 12 months, right? It could be of let's say November in 2016, and then as of 2017, no, you have to pay that. That's not so. That's a change, right? That's a change in a policy or a practice, right? And legitimate expectation seeks to defend the individuals from that, right? There is some legitimate expectation. No one would have expected. He had a legitimate expectation to believe that he could have completed university, right? A complete legitimate expectation from the government, right? The government can't just create a policy in 2016 and then just not create a policy in 2017. Just kick out a piece of the policy in 2017. It doesn't work like that, right? So because of the rapid change, right, in the policy and the practices, legitimate expectation as a doctrine will assist individuals to be protected from those rapid and most times unfavorable changes, right, done by the legislature or the executive, right? We're looking at that, and the two cases that we'll use for that. What are the two cases that we will look at for legitimate expectation? Two cases. For legitimate expectation. Two. Guys, you have to have cases.
There's this case, the AG of Hong Kong versus a fancy name, McGinshu. I'll type it.
Okay, what occurred in that case?
This is where a Chinese origin he entered Hong Kong illegally and was allowed to stay under a policy. And then in 1980, the government of Hong Kong altered its immigration policy and arrested the respondents. He appealed against the removal of order, which was issued against him, but that appeal was considered without a hearing.
Okay. So you could use that case if you can explain it. Use the case that you know if you can explain it. Alright. Well, the main cases that we were using before were these two: Marks v. the Minister of Home Affairs and Argentina of Barbados. Barbados? Crazy. Barbados versus the Joseph and Boys 2006. Those are two cases that would nicely wrap that up. Can anybody tell me whether or not there's gonna be any success if we bring this action against the state? Do you think that there will be any success? Anyone? What would be your conclusion? Are there any success? What, Pleacock versus AGS?
No.
No? Okay, so why do you think it wouldn't be successful? Go ahead.
I think that he would be successful given that it was the precedent that was set before, whereas persons would get the education before.
Okay. So look at that was general precedent, and in 2016 they changed it, right? So remember, this paper is in 2017, the 2017 paper, right? Let's think about the year of the paper. The year is a 2017 paper. So in 2016, just last year, they stated that all the students in 2017 now will have to pay that, right? So somebody said no, it would not be successful. Remember, it's not the question is not asking whether or not yes or no is right, It's asking you to explain and discuss your answer. So the person who said no, why wouldn't this be successful? You have to provide a statement for why it isn't successful. And you're gonna be using your cases to support your argument that it wouldn't be successful, right? So you need to really look at that. So some persons will think it will be, some persons will think it's not. Do your entire IRAC format, figure it out in your conclusion, alright? So that's generally for the 2017 component, right? Of the public law.